Good morning. This is Cecil Wright, and I'm an attorney with the board. And if you've signed into this webinar this morning, the presentation is with regard to the county's role in the IUB's pipeline permit process. I'll give it a couple more minutes. Got another minute until the presentation is to start to see if anyone else is going to join. Those of you who are already signed into the webinar, we will keep you as attendees, and then I'll go through how, if you have questions, you can ask questions once I start the presentation. Okay, just appears it's 11 o'clock, so we'll begin. As you're aware, if you've signed on, you're probably either on a county board of supervisors or you work with the county board of supervisors. But the presentation today is to kind of give an overview of the county's role in the utilities board pipeline permit process. The process involves two chapters of Iowa Code 479, which is natural gas, basically, and then 479B, which is hazardous liquids. And the information that we're going to provide today is not pipeline specific. It's more of a general overview to discuss what the County Board of Supervisors' role is with regard to the pipeline process. And the role is set out in those two statutes, so it's a statutory responsibility that the Board of Supervisors have. And if you have questions about a specific project that is being either that has come before one of the Board of Supervisors or which you've heard is going to be constructed, there is information on the last slide that shows how to contact the board. And the slides themselves, the presentation will be uploaded or put on the board's website, so you can kind of go back and review it. A couple of housekeeping matters first. We are recording this presentation so that we will have it available if we need to provide it at some other time. We're also making this presentation tomorrow at the same time. So if you know of someone who missed today or you have to leave and want to see the entire presentation, you can sign on tomorrow. So if you have questions, either during or at the end of the presentation, if you're on your computer, there is a little hand that I think you should be able to see. You click on that hand, we will see that here, and then we will unmute you and ask you what your question is or what your comment is. If you are on the phone or listening on the phone, if you *3, it's my understanding that will show up here, and then we will unmute you, and you can ask your question or make your comment. So just a little background of the statutes. The two statutes, Chapter 479 and 479B, give the Utilities Board the authority over the construction, maintenance, and operation of natural gas and hazardous liquid pipelines in the state of Iowa. So in order for a pipeline company to construct a pipeline, they need to come to the board usually for a permit. There are some smaller pipelines that do not require a permit and do not require the board to go through that process, but most pipelines require a permit from the board. And that's what we're kind of going over today, is how the Board of Supervisors fits into that permitting process. So hopefully all of you can see the the presentation, I'm going to walk through each of the slides and present the information. We'll go to slide 2 then. And what slide 2 provides is an overall view of the pipeline permitting process. And it kind of walks through the sequence of events from the beginning where the pipeline company determines that they want to build a pipeline. The statute requires them to hold informational meetings if they are of a certain length and pressure. And those informational meetings are held in the counties. For those of you who are in counties where the Summit Carbon pipeline is proposed to be constructed, those informational meetings are ongoing now. Probably some of you have had experience with smaller pipelines, and some of them may have even had experience with like the Dakota Access Pipeline or some of the others. All of them that are of a certain length are required to have the informational meetings. And those informational meetings are required by statute to be held before the pipeline company can begin negotiating with landowners to determine the exact location and whether they can get voluntary easements from the landowners. So and that shows there on the chart. And then after the pipeline company determines the route and the specific route, then they file a petition with the board, which lays out all the specifics. It identifies the land over which the pipeline will be located. It provides all of the design information and meets all the requirements that are in the board rules. And once that petition is filed, the board has a safety and engineering staff that reviews the information in the petition. And also, the board itself will review the information, because when a pipeline permit is requested, a hearing is required by statute. And that hearing follows the board's hearing procedures, which requires pre-file testimony, and we'll have an evidentiary hearing, and then the board will issue a decision whether to grant the permit or not. And then if you go on down through that, it says if the board approves the permit, then the pipeline construction will begin whenever the company has the permit and is prepared to begin. And then after the construction is completed, the Board of Supervisors will need to determine whether the pipeline construction is complete, and then the company will file information including as-built maps and their information about the construction with the board and with the counties. So that's kind of the overview of, that's the sequence of events. As I said, the presentation will be on the board's website, so you can kind of go back and look at this if you have questions about, what happens during the permitting process. If you go to the next slide. So the first instance that the Board of Supervisors, the County Board of Supervisors, get involved with the pipeline company officially under the statute is when the County Board of Supervisors receives notice of the proposed construction of the pipeline, and that informational meetings will be held in the county. The County Board of Supervisors is required by statute then to appoint or hire a county inspector. And the board's rules and the board recommends that the hiring of the county inspector occur early in the process, so that the county inspector can be at the informational meetings, and so they can listen to the information presented and begin the process of preparing for the construction at that point. So the slide indicates that if the pipeline company does go through several counties, the county board of supervisors can discuss with other county board of supervisors and hire one county inspection company to inspect the pipeline in one or two or more counties. If during the process of the construction the county inspector is changed, then the board of supervisors should notify the pipeline company and keep them up to date and provide that information to the utilities board. And all reasonable costs with regard to the inspection are paid by the pipeline company. That's something the county board of supervisors should discuss with the pipeline company when they are notified of that the construction is proposed to go through their county, so that they can work out whether they need a contract or whether they just need how they're going to receive payment. And so that's something they need to talk to the pipeline company about. So go to the next slide. So this slide kind of includes the information that should be provided by the inspector to the board of supervisors. And as the slide says, for a successful inspection program, the inspector should be collecting this information and have it organized. But if you can see there, that what there was recommended is that the inspector create a template or a form for to put all of the information in about the pipeline and the construction as it progresses through the county. Probably the inspector and the board of supervisors need to discuss how they want that organized, or how the inspector proposes to organize it, and make sure that the county knows what kind of information that they're going to be provided. And as you see there, the list, you can kind of go through that. I think one of the main things is for the inspector anyway, is the IUB docket number. The board will give each pipeline permit petition a docket number so that we can keep all of the information that's filed in that docket in our electronic filing system, so it's available to the public. And then as you go down there, you have a report ID number, the county inspector's name, the date, counties, things that you would expect to have in a report from your inspector. I think the main thing is on the second column there, it's the detailed records of all work performed throughout the day, and recommended that a separate report be completed for each permanent tile repair. I think there will be a lot of records, especially for a long pipeline that goes a long distance in the county, because of the detail that's required during the construction to keep track of the activity, and especially if there's tile work or there's tile that needs to be replaced or that is affected by the pipeline. And then if you look down there, it says deviations in work due to landowner agreement. The construction of the pipeline is actually follows three standards. One, the board has a Chapter 9 with regard to restoration of agricultural land that has to be followed. There's also some statutory requirements, but also the pipeline company and the landowner can agree to deviations from that. And so those are also need to be followed, and the county inspector should have all of that information as they go through, and they know which landowners have agreed to deviations, and also they should be very familiar with our Chapter 9 restoration rules. And then, as you can see, it also includes photos. So as I indicated, it'll be a very comprehensive report when they start filing those. Next slide. So this slide kind of gives some more information about the organization of the information to be provided by the county inspector. And I would think if you hire an inspection company that has done these kind of pipelines before, inspected these pipelines for counties before, they should have a system set up. And if not, if it's someone who has not done this before, you need to make sure that they have a system set up for organizing all of the information. And I think it's recommended at this point in time that that it be in electronic format, and that would mean that the counties or the board of supervisors would have to have an electronic file that can receive all of this information and keep it organized, and so that the county board of supervisors can refer back to any information if something comes up. I think if the county is not able to, or does not have the capability to maintain electronic files of this volume, you can require the county inspector to provide you paper reports and paper information. And as it indicates there, you create your folders based upon tracks, and it's my understanding that the track is created or designated by the pipeline company, and it will probably include one or more landowners, and it's probably based on engineering specifics. But that is the way that I think normally that this information is organized. And then you have a report ID number and the type of report. And you'll have different reports. You'll have your tile reports and your, clearing reports, and when they start trenching, you'll have reports about topsoil and removal of the topsoil and those kind of things. And I've got Majid Yusuf here with me, who's the manager of the safety and engineering of the Utilities Board. Is there anything else, Majid, in those files of how they're the types of reports that you're aware of that kind of provide an example?
I think it covered all, Cecil. I think those just something that you will be able to recognize what the report is and what associated with which landowner or which parcel is. That's the main goal of those reports, and have a way of name them that can be easily identified.
Okay, thank you. And we do have one early question in the chat, and I think we can probably do that. I will have to check with, but I know we're going to put it on the question is, will this presentation be available to review later on or sent via email? And I know we're going to put it on the board's website, but I think if someone were to contact the board and want the presentation email, I think that is something the board could do. Okay, so next, so one thing, I forgot to mention about the county inspector. The board has our rules at Chapter 9, but we also have developed a manual for the county inspectors, and that is provided to the county inspectors once it's indicated who will be the county inspector for a county. We also make board staff available to discuss if they have any questions about the inspection manual or the inspection process, and we also will respond to questions throughout the construction if they come up. So this next slide is the pipeline sequence of the project sequence, and this is. Let me turn the page. So this is the flow chart, or shows you how the construction will proceed. And as it goes back, as you show, there's a request then to the County Board of Supervisors for the informational meetings. The County Board of Supervisors appoints the county inspector, which, as I indicated, they're required to do by statute. Yeah, hold the informational meeting, and then there's right-of-way staking, the clearing, the boring, there's topsoil removal. All of these items are discussed in the county inspector's manuals and in the board's rules, and set up standards and requirements for how this is done, and how it is supposed to be done, so that it doesn't have, so it has the minimum effect on the landowner's property. If you go on down through there, then it's restoration of, and revegetation. You have to backfill the trench, and it's all, the goal is, based upon these standards, that the land be put back as close as possible to the way it was before the construction began. And then at the end, there's the company will test the pipeline, and then when it's all over, and construction is determined to be complete, the county inspector will file all of the documents that they have with the and provide those to the county to the Board of Supervisors and to the company. Next slide. Okay, going back just a little in the time, before construction begins, the county inspector is expected to obtain the following information from the pipeline company, and it would be the expectation then that once the county inspector obtains this information, they provide this to the Board of Supervisors. And I will answer. I have another question in the chat, and I'll get back to that just as soon as I finish this slide. So as you can see, there's a list of the information that the county inspector needs to pick up or to obtain from the pipeline company. Alignment sheet showing the tract information, project route and right-of-way, project specifications and procedural manuals. The list, when it says of affected persons, it's really the landowners or anyone who has a legal interest in the property, including anyone with a lease. And then, as I indicated earlier, there's the independent landowner agreements. Once the pipeline company starts negotiating with the landowners, they can agree to voluntary easements. They can also agree to changes in some of the standards if the landowner requests something different than what's required by board rules or the statute. And then the landowners are requested to provide their tile maps to the pipeline company and to the county inspector. And then, of course, the pipeline company's contact information, if they hire a contractor, the contractor's information, and the point of contact for not only the county inspector, but the landowners and even the Board of Supervisors. And then the county inspector will then provide to the pipeline company a list of their personnel who, if they have assigned specific engineers to specific counties or specific property, they'll provide that. And they'll also provide that information to the Board of Supervisors. Now I'll go back to the second question that we have. The question is, if there is damage to a public drainage tile during construction, do drainage trustees have the option to hire a separate engineer to assess damage if they so choose? And I think that the property owner or the public drainage whatever it is, public drainage organization can always bring in their own engineer. I think you'd have to contact the county inspector and let the pipeline company know that that's what you're doing. And the pipeline company should have already discussed this with you. And so at that point in time, the drainage trustees can explain to the pipeline company they want to bring in their own engineer if there's damage or if there's an issue. And I think that can be negotiated. And but you need to involve the county inspector in that, because the county inspector has the ultimate responsibility to sign off on whatever changes are made or whatever issues that arise, and whether the correction made by the pipeline company meets the requirements of the board rules or the statute. Next slide.
Just want to add to the Cecil point here. Also, the pipeline company are required to repair the tile to previous function, or even better, if that's not the case, the drainage owner, they can come back to the company through the county inspector and ask him if there is any issue with their drainage tile at that point. But the pipeline company have to repair the drainage tile to previous function, or even better than what have before. So.
Correct. Thanks, Majid. And we will go through the process of, if there's an issue with the construction or with the restoration, what that process is on how that get that corrected, if the company doesn't do it voluntarily or at the time. So the next slide just goes through again that the county, as I indicated, the county inspectors will be generating a significant number of reports. And so that's why you need to have, they need to have a detailed plan for organization, and they need to talk to the county board of supervisors and work that out so the board of supervisors can store that information. And we'll have that information. If any questions about what happened on a certain piece of property or during construction, if one of those questions comes to the board of supervisors. As it indicates here, it's always good to be talking to your county inspector and making sure that, you know, they understand what the board of supervisors requirements are, and the board of supervisors understand what the county inspector's responsibilities are. And as well, Majid indicated, if you look at that next paragraph, that next bullet point there, it talks about the what happens if there is a violation of the standards, or as the question asks, if there's a damage to the public drainage tile. And there's what we call a notice of violation process. And the first one, of course, is if the county inspector or the landowner sees that there is an issue or something that is not being done in conformance with either the board rules, the statute, or an agreement with the landowner. They present that to the contractor or to the pipeline company orally, and then if they discuss it and the pipeline company or the contractor makes corrects that, then there's no problem. The construction can proceed. If during that discussion the contractor doesn't agree that it's a problem and is unwilling to correct the issue, then the county inspector can issue a stop work order, and the statute says they can temporarily stop work, so they can tell the contractor to stop work until they work out that issue. If the pipeline company still doesn't agree or doesn't want to take the corrective action, there is a third step that involves the county engineer presenting a written notice of violation to the county board of supervisors, and then the county board of supervisors will review that, and if they agree that it is a violation, they can if they think it's a serious violation, they can file and ask the board to issue an order requiring the pipeline company or the contractor to correct the situation, or they can not take that action, and then it'll be something that'll have to be worked out before the construction is complete. If you look down at the bottom of that slide, it says a written notice of violation shall include, and that just basic information, the location of violation, the explanation of the violation, time frame of the violation, and the written notice. So if you go to the next slide. So this is the completion of the project. And the county is, once that the pipeline company and the contractor have determined that they've completed construction. Did I miss one? Oh, looks like I missed a slide. Board of Supervisors notice violation. Sorry, I turned mine over and went to the next page. Okay, after receiving the notice of violation from the county inspector, the Board of Supervisors will decide whether or not to proceed, and that's what I indicated before. As this lays it out for you, if the Board of Supervisors decides not to move forward with a notice of violation, the county inspector should provide the applicable landowner with the original written notice of violation, notify the pipeline company the landowner has been informed, and include the violation or inspector's restoration on the restoration punch list. And as I indicated, if the Board of Supervisors decides to move forward with the violation, they will file a petition with the IUB and request an order requiring the pipeline company to take corrective action. And at the bottom of that slide, it states it is recommended the Board of Supervisors not consider the construction complete until each violation has been fully remedied or a signed agreement between the landowner and the pipeline company has been approved, provided by the county board, by the county inspector. And that really brings us to that last slide, which is completion of projects. The county inspector the pipeline company will let the county inspector know when the pipeline company considers the pipeline construction complete in the county, and then the county inspector shall determine whether they believe the construction is complete based upon the final restoration has been completed and that the vegetation across the project has reached 70% of its growth. So that's kind of the triggers for when the inspector will look forward to determine whether the construction in that county is complete. It's actually the Board of Supervisors are the ones that make the final determination of whether the construction is complete. And that's based upon usually the county inspector's reports, and then after the Board of Supervisors determines that the project is complete, the county inspector will finalize all their project documentation, and we'll turn that over to the county Board of Supervisors and to the pipeline company. And there's a list of the information. And just the board's experience has been that in some counties, because the punch list, which the county inspector will keep a punch list of all open items and items that need to be corrected. And if that punch list has not been completed, if there hasn't been an agreement with the landowner that the landowner is satisfied with the restoration, or if the county inspector hasn't closed those punch lists, then usually the Board of Supervisors doesn't find that the construction is complete. And in some instances, that can take several months after the actual construction of the pipeline, and as far as the company is concerned, and that the pipeline is complete and ready and has been tested and is ready for operation. So I think just to go back over, I think the main points are that the statute really has the Board of Supervisors three important places or requirements with regard to pipeline construction. They are required to hire a county inspector to inspect, and any cost of that county inspector will be paid for by the pipeline company. They are then part of the process if there is a notice of violation that's filed, and it comes to them, it can't be corrected, it comes to them, then they are notified of that, and they have to make a decision whether that needs to go to the utilities board or not. And then at the end, that it is the county board of supervisors that makes the final determination for that county whether the construction is complete, and that's usually by resolution. And then the board asks that once they issue that resolution, that the board of supervisors file that or send that to the utilities board. They need to provide that to the pipeline company, and of course provide that to the county inspector. And it's expected that the board of supervisors will be discussing with the county inspector that final decision and whether all of the punch list items and there's any other items that need to be corrected before voting on that resolution and issuing it. So that's kind of a brief overview. I've kind of just run through this. We will be providing the manual for the county board of for the county inspectors. We will make this presentation available both on the website, and I think if you contact the board, we can send it to you by email. And if you have any questions, if you notice on the last page, gives you the contact information for the board. Yeah. Okay, so and then I think was that on there? 11. Oh. So this is I did miss one, and this is one that we added yesterday. There is a process after you determine that construction is complete. Landowners who are not able to reach an agreement with the pipeline company for damages for any damage that has been made to the property or that they believe has not been appropriately compensated, and where they can't reach an agreement with the pipeline company, 90 days after the board of supervisors determines that construction is complete, the landowner can request that the board of supervisors appoint a compensation commission to determine those damages. And then if the board of supervisors approves the petition, then the landowner or pipeline company may commence the proceeding by filing an application with the chief judge. And if you have more questions about that part of it, the board has a handout and it's on the board's website that walks through that process of a landowner requesting compensation commission, and then what the process is after that. So, is there another question there? Okay, the next question that I have, is can the board designate the inspector to be able to act on their behalf for a violation, or must the board of supervisors act specifically on violations themselves? So I think when you walk through that process, the inspector really has the authority to tell the pipeline company or the contractor orally if something is not done in accordance with either the rules of the statute or an agreement with the landowner. If the contractor doesn't do that, the inspector then can stop work and go and explain to them and talk to them and try to what we call issue a work order, stop work order, and say, you need to fix this. I think it only will come to the board of supervisors if that process doesn't work. If it's still something that's significant and the inspector feels like it needs to be corrected before construction continues, that's when it will come to the board of supervisors. And I think it's our experience, I just imagine, that usually issues don't rise to that level. They usually get worked out between the inspector and the contractor and the landowner. Is that right, Magic?
That's right. Typically, they hold that issue between them. And
I don't know that we've ever, in my experience, had a board of supervisors actually bring something to the board under this process, that third step. I think usually issues are worked out, or there's some accommodation made during the construction between the inspector and the pipeline company. Okay, and the next question is, can Board of Supervisors set depth of pipeline to protect the infrastructure already in place? So that's a good question. I think in order to change the depth of the pipeline that is being proposed for construction, that the Board of Supervisors would have to intervene in the case and have the board determine that that was the appropriate depth of the pipeline. I don't think that the Board of Supervisors can set the depth on their own. I think that the way I understand it, and I may be wrong, this is just in response, I hadn't really thought about this, but the pipeline project, the pipeline company will file as part of their petition the depth that they propose to put the pipeline. They will put in there how much separation of the pipeline there is between the pipeline and any tile or any other underground facilities that are located there. But then that is then for the board to review and to determine whether they agree that with what's been filed, or if there are parties or other people who file that do not believe that is sufficient or is not sufficiently deep, then that becomes part of the evidence in the case for the board to decide. So that's my opinion. I will double check, and if you want to send that to the board as a question, we will run that by our general counsel and see if he agrees with me.
And I will add to Cecil, for the depth, the Board of Supervisors can always talk to the company and ask them to lower their pipeline or have it set a certain point because of their underground facility there. So you always can go to the company and ask them to put the pipeline in certain depth. If that doesn't work, then that's probably another step that we need to look for and see what the process there is. But you can always talk to the company and ask them.
Yeah, and that's always the place to start. If the county feels that the pipeline should be at a certain depth, or there's certain facilities they would like, them to have different separation, the place to start is talking to the pipeline company and see if you can work that out ahead of time. But if it's not able to resolve it, it really becomes an evidentiary question for the board. So then we've got, the next question is, what are the implications for the pipeline company of a county not declaring the completion of the project? So the experience the board has is that if the board grants the permit and construction is completed and in accordance, and the board doesn't have any issues with it, that the pipeline company can go ahead and begin operating. What is left out there is this issue of any damages or any restoration that they need to make based upon any existing issues that remain. It's been our experience that the completion is really needed so that landowners who can't reach agreement with the pipeline company can go to a compensation commission and get a compensation commission to determine damages. And then the next question is there specific distances the IUB recommends having the right-of-way of the pipelines be away from buildings and residences? And I'll turn that over to Majid. I think, especially for natural gas, there may be some federal standards. I don't know if there are for hazardous liquid.
There is no requirement over the federal code for distance between pipeline for hazardous liquid or natural gas from a building. The only requirement is it can't be underneath the building because they have to access to that pipeline. The other thing also I want to mention here, the pipeline company are required to look for what we call high consequences area, which is when they put their pipeline near a building, that will they have to create another integrity management program for that pipeline in that location. That integrity management program, it costs the company have to do like maintenance, they have to run internal device on the pipeline, and typically the pipeline company try to avoid those area as much as possible unless they have to. So most likely the company probably not going to be like to have their pipeline next to the building because that will create that high consequences area for them, and they have to develop an integrity management program for that pipeline at that location.
Yeah. And I think just what Majid is saying is there are federal regulations that apply if the pipeline is proposed to be within a certain distance to buildings. And so the company has to comply with those. One is the integrity management plan. There's also other requirements, safety requirements, and they have to provide evidence showing that they are complying with those federal regulations when they file their testimony in the board, before the board for the hearing. And that those are the kind of issues that the board looks at to make sure that the pipeline is proposed to be constructed in conformance with all the federal and board regulations.
That's correct.
Okay, then the next question is, are zoning requirements enforceable for pipelines? Requiring conditional use permits and conditions attached. And I think the answer to that is that pipelines have to provide the board all of the permits and authorizations that are required by either a state or local rules or ordinances as part of the permitting process. So my answer to that is I think that the pipeline company would have to get whatever permit that the county has with regard to zoning requirements, or however the county requires a pipeline to, or whatever requirements the county has for the pipeline. Is that your understanding, Majid?
Yes, that's correct.
Okay, another question is, what are proposed projects qualities that the IUB reviews to determine approving or not approving a project and allowing the use of eminent domain for the compliance? So the statute really sets the standard, and it's kind of a general standard. It says that the pipeline has to meet the requirements of public convenience and necessity. And that's been left kind of general because each pipeline is a little different. And we have some court cases on that kind of lay out some parameters and what the board's authority is with regard to that and what evidence is necessary in order to show that. But it really is a case-by-case basis where the pipeline company will just have to show that the project meets that standard, which, as it indicated, is kind of a general standard of public convenience and necessity. The use of eminent domain is really a separate issue. So for eminent domain, the statute, of course, allows a pipeline company to request the right of eminent domain. And then, as with the other parts of the petition, they would have to show that the request is necessary, that they need that property, and that's where the pipeline, that's the best place for the location of the pipeline. And then it's up to the board to decide whether that evidence supports the granting of the right of eminent domain and if there are any conditions or restrictions on that grant. So it really becomes almost a parcel specific issue that is part of the evidence that the board reviews in making its decision. and I'm gonna check with my tech people. Is that all the questions? Have I addressed all the questions?
Anyone raise hand or?
Is anyone raised? I don't see any raised hands, do you? And I don't see any indication of anybody on the phone. Okay. So I appreciate the questions. It's really important, and I think if you have follow-up questions, I think, contact the board. And we'll get you an answer the best we can. The next question that has come up is, does the Board of Supervisors have a role in eminent domain proceedings? As I indicated earlier, if the Board of Supervisors wants to participate in the evidentiary hearing and address the eminent domain or any of the other issues, they would have to file a petition to intervene as a party in the docket. It's really, it's the board's decision will be based upon the arguments and the evidence made in the docket, and the board will look at that evidence to determine whether eminent domain should be granted, and if it should be granted, if there are any conditions on it. And so it's really the board's decision. And I think if the Board of Supervisors has a position on that, they really need to provide that in the docket. Any other questions? We've still got a few minutes here. And as I indicated, I appreciate the questions. They really help. And I know there'll probably be more questions after you go back and think about it and kind of look at this, especially if you have a pipeline company coming through your county and you've been contacted and you're hiring a county inspector. I think you need to make sure you discuss with the county inspector what you expect of them, how their information is going to be organized, how they provide it to you, and then make sure that they keep you informed of what's going on and any problems they have. Do you have anything else, Maggie, that you think we've missed?
No, I think that's covered all. Thank you for participating today.
Okay, thank you for participating, and I guess we're going to do this again tomorrow, so if you think of a question and you want to come back tomorrow, you can ask it tomorrow. Thank you.
Thank you.
We're adjourned.